Well, it seems that everything Disney touches turns to woke and apparently turns racist as well. This week, the Lion King Broadway show in New York allegedly fired sign language interpreter Keith Wan for the very high crime of being white. This isn't just another case of he said, she said. We have receipts. Keith Wan received an email from the Theater Development Fund Accessibility Programs on April 2nd, he says, in which they wrote, "It's no longer appropriate to have white interpreters represent black characters for ASL Broadway shows." I know, you know, the old trope, the old, could you imagine? But could you imagine if a black man was fired from doing sign language for a play because he was black? Could you imagine the nuclear outrage? And by the way, that would be justified outrage. I would be upset about that. It's why I'm upset about this. There would be already riots in the streets over this. And the show would be canceled, by the way, of course. There would be as much backlash as you can imagine. The most Wan can do at this point is sue the Broadway show, so that's what he and his attorney, Josh Pepper, are doing. I wish them best of luck in their endeavor. Criminal defense attorney Bob Bianchi joins me now with a legal perspective on all of this. Bob, so it appears that he was fired for being a white sign language interpreter. Granted that that's true, it would seem that he's going to have a very successful lawsuit.
So we break this down into three buckets, Addison. The first one is the Civil Rights Act of 1964, Title VII, prohibits any discrimination based upon race, sex, national origin, so on and so forth. And it doesn't apply, it doesn't say whites, blacks, Hispanics, Asians. It's any race, period, end of story. So it's a gender and race neutral law. The second only exception to that is the bona fide qualified occupational rule, as they call it, which essentially says in some limited circumstances, if it's absolutely necessary in a business context for the conducting of the business, then some level of quote unquote discrimination would be allowed. For example, Addison, certain age requirements for a school bus driver would be an allowable discrimination in that context. And they actually address actors and models, which is another subset there. In there, it could be appropriate. For example, all of the actors, I believe, in The Lion King, I've never seen it, are probably African American, and that would be contextually okay because of the nature of the production. So, sorry for the third bucket. The third bucket are the facts. If there is, can they prove this bona fide occupational exception to the Civil Rights Act? And where I think they're going to have a huge problem is, one, they already hired the guy. So obviously when they hired him, they didn't think that there was anything wrong with it. That's going to be a fact that's going to be very bad for the production. Secondly, there were other emails that were basically saying, well, you know, it's the Times. That's not a bona fide reason to say it's the Times. And also them saying in the email response, which is amazing that they would put this in writing. It's kind of audacious that it's not quote unquote acceptable anymore. I don't believe on those three facts and probably more that are going to come out that a court is going to find that the bona fide occupational qualification rule is implicated here. Therefore, they'll find it as discriminatory.
Yeah,
Sorry for the long-winded, complicated legal answer.
Yeah, well, no, I appreciate that analysis. I think it's important for our audience. The way I look at it, if a company is going to be racist, at least be a little more discreet about it, right? If you're going to racially discriminate against a white guy, don't email him saying, you know, essentially that we're going to fire you because we need someone who's black. They could have at least, would they have been able to loophole this a little better and avoided a potential lawsuit if they had just kept it more vague and said, you know, we're not happy with your performance, we're looking for a different fit or something? That seems like it would have been the objectively better route for them to take, but they just outright said, hey, you're white, get out of here.
Yeah, you could have said a more wrong thing legally than what they put in that email. I mean, you first of all, you should have human resources in your legal team that are advising you with respect to this. Because say, for example, that their argument is like, look, they're black characters and we want to have a black interpreter in order to have a more unique and genuine experience. That is a far better response than saying things like, you know, it's not appropriate any longer and, you know, sorry about this, but it's the way it goes, and then already hire someone in advance. So it's just the worst thing that they could have done.
Yeah, yeah, not a good look for them at all. So, granted, I don't know how all this is going to pan out. It's all, I have to, of course, say that this is all alleged. But granted that it's true, I look forward to seeing how much money Keith Wan will win from this lawsuit. Another thing I want to get your thoughts on, Bob, before we get out of here. Samantha Shader, 29. Has pleaded guilty to one count of using an improvised incendiary device in April of this year. We have the mugshot of her. She has been charged in New York after she threw Molotov cocktails at police in June of 2020 during the Summer of Love riots. Bob, break down this case for us.
Listen, when I was prosecutor, we would have groups that disagreed. I can think of one major immigration rally, pro-immigration, those who were on that were not. And we were very attentive as law enforcement to say, look, get your permits. Here's your staging area. We want you to express your First Amendment rights and your right to assemble. We really, deeply cherish that. But if either side, I don't care, steps over the line and creates some sort of level of violence, you will be arrested. And that's the way it should be. And what's really sad about this is, one, first of all, attacking cops like this, it's just, regardless of what you think about the cops, I understand it had to deal with George Floyd, but you can't just broad brush an entire profession and innocent cops who had done nothing wrong be coming there with, apparently she alleges, was handed this thing and throwing them at cops. It's the breakdown of society. So this sentence was very stiff. It was very appropriate. You know what the other sad thing is, Addison, I got to say, and you may think this is counterintuitive. Those who protest, I don't care if it's left side, right side, or in between. The bottom line here is you're ruining your own life with this. You're not only putting other people's lives at risk, this person probably, we deal with lots of cases have led law-abiding lives, could lead productive lives, but they get such a frenzy that they breach that line where acceptable protests, acceptable expressions under our Constitution go to a point where it's violent. And that is where their lives will take a bad turn, as hers certainly has.
Yeah, I totally agree. Protesting, protesting is a First Amendment right in this country. Throwing Molotov cocktails at police officers, not a form of protected speech, because it's attempted murder in reality, Bob, which is why, 6 years, she's apparently being sentenced to 72 months in prison by U.S. District Judge Dora Izari. 6 years for attempted murder of police officers. That doesn't seem too harsh. I mean, correct me if I'm wrong here, but I mean, is it being charged as attempted murder? I don't see how throwing explosive devices at people can be charged in any other way.
Yeah, I hate to again drill down, but I'll tell you as a prosecutor, the hardest cases for us to prove were attempted murders, because you had to get into the state of mind of what the person wanted to literally kill that person. So I think that what happened here was probably the defense presented the case that I'm saying right now as a person who lived an otherwise law-abiding life, whatever, mitigating factors that they said for it. And, 6 years is a lot of time. I don't disagree with you that, look, there are judges that could have hit her probably a lot harder. And there are some judges who may have gone more lenient. I don't think that this is out of the bounds of reason as far as the sentence is concerned, since nobody was hurt.
Yeah, well, and thank God that no one was hurt. Otherwise, she definitely would have gotten longer than she is getting. Bob Bianchi from Law and Crime Network, great to have you on. Thank you for breaking down these cases for us.
Of course, Addison, thank you.
Coming up next.